Hello, everyone. Today we have Joel Conkin with us to give us a presentation. Joel Conkin is the principal shareholder of the law firm of J. Conkin Law, PLLC. Joel was born in Kingsport and received his JD with high honors from the University of Tennessee College of Law in 1994. Joel graduated magna cum laude from Tennessee Technological University, where he majored in accounting. Mr. Conkin's practices primarily in the areas of estate planning and administration and has twice served as president of the Tri-Cities Estate Planning Council. Please join me in welcoming Joel.
But whenever I give these presentations, I'm always reminded of like when I first started practicing law. I had a client, and like most of you, when you start out doing something new, you're sort of the low man on the totem pole, and you get assigned all these tasks that no one else wants to do, right? So we had a client that was an appointed criminal case, and he was actually on death row, and we were appealing his conviction, and it actually went all the way on up to the Supreme Court. And I wrote what I thought was a fantastic brief to the Supreme Court to try and get his conviction overturned, and the Supreme Court disagreed. So it came time for his execution, and the warden from the prison called and said, "He wants to see you." And I was like, "What? He wants to see me?" And so I went to see him, and the warden said, "Well, you've got 1 hour before the execution." And I walked in, and the guy was there, and I said, "I know you've got family. I know you've got friends. Why in the world did you want to see me?" And he said, "Well, you're the only man I know who can talk for an hour and make it seem like an eternity." So here we go. With that, we'll start our presentation. So Donna asked me to talk about two potential things, and one is some charitable giving tips, and two is estate planning, and those are both massive topics. So you've got a couple outlines. I didn't make enough for everyone. I apologize for that, but I'm happy to get you some more copies. My email, you can email me, and I'll send you as many as you like. But so I'm going to start with it being the end of the year. One of the most common things, I'm not a tax planner, and I know there's some CPAs in the room, so they can probably speak to this better than me, but one of the most common giving techniques that's a lot of people aren't aware of is what's called a QCD, and that's a qualified charitable distribution out of an IRA. And the way that works is it allows someone with an IRA, now this doesn't work with 401k, it has to be an IRA, to make a charitable gift directly out of that IRA. And you may say, well, why does that matter instead of writing a check? Well, the beauty of it is it counts as your required minimum distribution that you have to take out every year. So if your RMD were, say, $30,000 and you wanted to make a $30,000 contribution to charity, you can make that. You don't have to take another nickel out of your IRA, and you also have no income for the year, so you pay zero in taxes. Whereas if you took the money out of the IRA and then contributed it to the charity, you're subject to a 60% limit on your AGI, so you wouldn't be able to deduct the entire amount. So there's some benefits to doing that directly. And then there's some other reasons to do it, even if you do have other income. But that's one thing that people aren't always aware of. So that's one tip I would give you. Other tips, appreciated stock, giving that directly to a charity is beneficial in that you can avoid the capital gain that you might have to pay if you sold it and then donated the proceeds. So instead of doing that, just give the stock directly to the charity, and then they can sell it. And since they're a charity, they don't pay taxes on it. So that's a couple of things about the, from a charitable giving standpoint. There's lots of other techniques that we use, a little more sophisticated things like you have highly appreciated stocks, bonds, real estate. You can use what are called charitable remainder trust to avoid the capital gains on those transactions, and you can reserve yourself basically an income stream for the rest of your life or a certain period of time. And a lot of times when you run the numbers on those, you see that you actually, by avoiding the capital gain, and you can get more benefit out of it by doing that, then, and the charity still gets some benefit too. So that's a very powerful technique as well. So as far as, that's pretty much, obviously, any other charitable giving. If you just write checks, you're subject to a 60% AGI limit, which is adjusted gross income. So if you don't have a lot of income, you can only deduct up to 60% of your AGI. And another important thing, another reason that QCDs are valuable directly out of the IRA is if you use a QCD, you can still take your standard deduction on your other income. And so, also, if you don't have enough to itemize, then you're not really getting a tax benefit from your charitable deduction. So if you use the QCD, you could. So with that, I'm going to skip over to hit some high points about estate planning. And this could be hours, but I'm not going to put you through that. But so I just want to hit a few highlights. One thing that when people hear the term estate planning, what they really think about immediately is a will, who gets my stuff when I pass away. And that's obviously a very important part of it. But probably more important is having things like powers of attorney for health care that allow someone to act on your behalf in the event you have a disability and can't do it yourself. I mean, those are things that directly impact your own quality of life. Whereas who gets your stuff after you're gone, I mean, I know that's important, but frankly, it doesn't impact you directly, right? So those are pretty important to make sure someone has the authority to act on your behalf if you're unable to do so yourself. And otherwise, sometimes you're in court getting a conservatorship or some sort of legal proceeding, or your family's in court trying to get control and make decisions for you. So those are pretty simple documents to do, and can be frankly just lifesavers as far as your family's concerned, so they can act on your behalf. And another issue, a common question is, well, what if my kids' names or another person's names are on my bank accounts? Well, that's okay. They can access and control those accounts, but that doesn't mean they have authority to make a healthcare decision for you, or manage your Social Security, or manage an investment account or an IRA, or call and cancel your cable bill. All those little things that can be very important. So the other common question, probably most common question that I get, is last will and testament or living trust. And I suspect that many of you get these flyers in the mail, because I've seen them, that say you have to have a living trust or your estate's at risk. I'm not trying to sell anything, but I'm just curious, who in here's gotten one of those flyers? I know my mother-in-law got one yesterday. She showed it to me. Yeah, and they're scary. I mean, they say things like the court will invade your estate and all this junk. So let me just set that record straight as best I can, because I get asked that question a lot. So a last will and testament and a living trust do exactly the same thing. They say who gets your stuff when you die. I mean, that's simply put. The The difference between a living trust and a last will and testament, and there's no tax differences, okay? So if they tell you that, they're not telling you the truth. The only difference is a living trust avoids probate. In Tennessee, probate is a process that delays, takes usually about 4 to 6 months to settle an estate, sometimes longer. And, it's not free, so it does usually cost a few $1,000s or something in that ballpark. And again, this is all depending on the size of the estate and complexity. But the living trust people will tell you that, that's an absolute, you have to have it or you're at risk for all these different things, and that's really not true. Now, having said that, I do living trust for people every day who want to avoid probate and keep things confidential. That's probably the biggest point for most of my clients is if you do use a living trust, if you have a will, it gets recorded in the probate court. So we could all get in our car and drive to Bluntville right now and go look through everyone's will who's passed away in Sullivan County going back 200 years. And that's just a fact. So when you pass away, that will does get recorded permanently. And some people, that's not a big deal. So what? I left everything to my wife and kids, so what? But others, maybe it's not so straightforward, or they don't want that information in the public record. So if that's a concern to you, then you probably would want to use a living trust. The other reason that we often use a living trust is if people have real estate in multiple states. So then we're talking about possibly doing some sort of probate administration in, I've got a beach house in South Carolina, I've got a piece of land in Virginia, I've got my house in Tennessee, and then all of a sudden you're talking about doing things in 3 different jurisdictions, and that can get pretty expensive and time consuming and can be avoided using the living trust mechanism on the front end. But at the end of the day, everything you can do in a will versus a living trust, you can do, the end result is exactly the same. It's just a difference in process in getting to that end result, and the tax implications are the same in both documents. So that's one topic I wanted to cover. The other topic I wanted to cover, and there's a lot more information in here, is gifting. This is another very common question. People come up to me and say, can I make a gift to my kids or my grandkids? And what are the rules around that? And they say, well, I can give them $10,000 a year, right? And the answer to that is yes, but that's the old rule. So Tennessee used to have a gift tax, and you had an annual exclusion, and that annual exclusion amount is now $18,000 per person per year. Federally, Tennessee repealed its gift tax about 6 or 8 years ago, maybe longer, time flies. But so Tennessee no longer has a gift tax. So federally, the rule is you can give $18,000 per person per year to anyone you want. Family member, friend, doesn't matter. Attorney, if you're really interested in giving them away. But if you want to go above that, this is where the people don't understand commonly, is if you want to go above that amount, under the current federal law, you can give away $13.6 million and pay zero in gift tax because you have a federal estate and gift tax exemption of that amount, which you can use either during your lifetime or at your death. And the federal government doesn't care when you use it, but you can only use it once. So if you write that $13 million check and use it all up, when you die, whatever you own is subject to estate tax at that point because you don't have exemption left. So that's how that works. So another aspect of gifting that's a very common question is, well, why don't I just go ahead and give everything to my children now? Well, one reason is, well, what if they get divorced or go into bankruptcy and you've lost your stuff? You don't have access to it. So that's a big risk. So I don't encourage that very often. But The other issue is basis. A lot of estate planning now is not estate tax because the exemptions are so high. I mean, I have some clients that still deal with that, but fewer and fewer. What we deal with a lot is basis for capital gains tax purposes. So if you inherit a piece of property, your basis for capital gains taxes get stepped up to fair market value at the date of death. And what that means, for all practical purposes, is your heir, your beneficiary, can turn around and sell it the next day and pay no tax on it, which is a big deal if you've got a highly appreciated piece of real estate or a highly appreciated stock. So these things, I know it's kind of boring, but it can be significant to your family from a capital gains tax standpoint. To even if you don't have anywhere near $13 million in assets, the basis management is still very important because everyone pays capital gains taxes, if they sell an appreciated asset. And so I'm running out of time. I just want to hit a couple more points. People ask me what's changed in estate planning, since I started it 30 years ago. And probably the biggest thing is the use of irrevocable trust. That's become much more popular among my clients, especially people that have some wealth that want to leave assets to their children, but are worried that their children either aren't very good managers of the money, or they're worried about their children getting divorced, or they're worried about making sure that whatever their child doesn't use goes to their grandkids, or all of the above. And so a lot of times, instead of having documents that just say my child gets X, we say, well, my child gets X in trust. And sometimes we have a third-party trustee managing that. Other times we let the child act as their own trustee. So in that instance, you're not really protecting them from themselves. But if their spouse walks in and says, I want a divorce, that money's has a hedge of protection around it because legally it's owned by the trust and not by your child. So that's been a big change. We do a lot of that just in an effort to create some asset protection for the next generation and then even the grandchildren. So I'm running out of time, so I'll stop here. If there's